are in a listen-only mode. For those who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write down this code as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker, Jennifer Mora. Jennifer, please go ahead.
Thank you so much, and thank you to you all for joining us today. We're really looking forward to talking to you about what is one of my favorite topics, marijuana, and what we're seeing happening nationwide. What prompted this for us today is the recent enactment of recreational marijuana laws in New York and New Jersey. I'm a senior counsel in San Francisco. Joining me today are partners Rob Ziba in our New York office and Adam Young in our Chicago office. We have a lot of material today, so I'm just going to go ahead and dive in. Just to kind of give you an overview of what you're going to hear about today, I'm going to talk briefly about what's happening nationally, just kind of set the stage for some things. I'll turn it over to Rob, who will then talk to you about what happened recently in New Jersey and New York as they relate to recreational marijuana laws. And then we're going to kick it over to Adam, who's going to really talk with us about some safety considerations in both of those jurisdictions, but elsewhere. This is becoming a really big challenge for safety-sensitive employers, and so we want to make sure that you walk away from this webinar today with some things to think about as it relates to safety. We'll close out with some additional other considerations kind of nationally that go beyond New Jersey and New York, and then give you some final thoughts. We do encourage you to ask questions in the chat. As the disclaimer said, we're not providing legal advice today. If you have any specific questions about situations that you're dealing with in your own employment world, you're probably going to want to reach out to your counsel, but we're happy to answer some general questions, and we'll be sure we're able to do so towards the end. Just a real quick plug, Seyfarth has a blog called The Blunt Truth. I am the assistant editor, and we really try to put out a lot of legal content that not only focuses on unemployment issues with respect to cannabis, but real estate and commercial transactions, FDA regulation of CBD. So we encourage you to subscribe, and with that, let's talk about what's kind of set the stage for things. So as you probably all know, cannabis is still illegal under federal law. That has been the case since the early 70s. That is unlawful per the Controlled Substances Act. And essentially the reason it is illegal is that the administration, Congress at the time, decided to classify it as a Schedule I controlled substance. Essentially what that means is that there's a high potential for abuse and limited medicinal value. That's been the view for decades. Obviously, we'll be talking more about how that trend has been shifting the last couple of years. We're seeing that at the state level, and that's what's bringing us here today, is that states across the country are passing cannabis laws, whether it's recreational or medical, or it could be decriminalization, which is different than recreational. We won't talk much about decriminalization. We will focus more on recreational and medical. Many of the laws, we'll talk about some of those specifically in New Jersey and New York, actually have express employment protections within them. Some of them are implied, and a lot of them are growing out of the cases that are coming as a result of the passage of these laws. We're seeing litigation growing. Most of it so far has been on the East Coast, but we think that as these laws start to evolve and more laws are passed, that we'll be seeing more litigation across the country. Until the federal law changes or Supreme Court says something about the issue, employers are really kind of left to struggle, especially since laws across the country are not uniform. They really have their own text. They have their own courts interpreting them. There is some talk that there might be something, a change under the Biden administration. One thing I, kind of tend to think is that right now the Biden administration is probably busy with COVID and all of the other things going on right now. So it remains to be seen. Every administration says they're going to do something about it, and here we are, almost 50 years later, and it's still illegal under federal law. So why are states taking action? Why have they decided to do something? And it's really because there's varying views out there, and more medical and scientific opinions are coming out that are saying different than what the federal government says about marijuana, which is that it can be used to treat some health conditions. Most notably, and what we see in our practice a lot is usually epilepsy, anxiety, depression, or even managing pain. One thing to note, we hear this a lot, is that employees, applicants, people are not prescribed marijuana or cannabis. That would be a violation of federal law. They are usually receiving a recommendation from their doctor in the form of a letter or some sort of a referral, and then depending on the state, they then go down to the state and get their card, or they register, or whatever it is they have to do. So be careful about when you hear somebody's, oh, I was prescribed marijuana. It's technically not true. And a lot of jurisdictions are just essentially saying that marijuana and cannabis, they're no different than any other types of pain management drugs like insulin, Percocet, stuff like that. And really, I think what is driving most of this is there's just a strong cultural shift. Every year they do polls and they find that the majority of Americans do support legalization. And my guess is that given the trend at the state level to legalize the drug, we're probably going to start seeing more Americans pushing for kind of a more national response. This is the list of jurisdictions that currently authorize medical use. Those that you can see this covers more than half the states. Those that are in bold and underlined are those that we consider to be very employee applicant friendly. That could be because the statute specifically provides employment protections to an individual, or in the case of Massachusetts, for example, there have been some court decisions, and we'll talk about those later, that have provided employment protections to applicants or employees. So that's the state on medical. Recreational, this list just keeps growing. I think last year when I looked at the list, it was 4 or 5 short. Now it's growing. So you can see we put together this really nice map that shows you how green the country really has gone. And I believe that you'll have these slides at the end, and so you'll be able to refer to this. Hopefully you'll get them in color, but if not, at least you have the slide on the 2 previous slides that have a list. But we even focused on what we're seeing, and we'll talk about CBD later, are some jurisdictions are actually legalizing CBD, and we'll talk about Virginia, which just passed a law providing protections to people who use CBD. So with that, I know you're all here to really hear about New Jersey and New York, so I'm going to turn it over to Rob, who is going to tell us what happened in those 2 states. Rob?
Absolutely, Jen. Thank you so much. Yeah, New Jersey and New York have been very active on this front and have passed probably some of the most expansive laws in this area. So let's talk about New Jersey a little bit. So New Jersey is actually a really interesting history, and it's kind of interesting that we're talking about the recent legislation in New Jersey, because it's really been happening for about 11 years now. Back in 2010, with back then it was Governor Corzine. He had passed legislation called the Compassionate Use Medical Marijuana Act, but it was rather limited. It was limited to a certain amount of medical conditions, and that law was passed, I want to say, about 3 or 4 days before he exited office and Chris Christie took over. Chris Christie was famously opposed, called marijuana advocates crazy liberals, and said that they wanted to poison our children. So it did not get a tremendous amount of support while he was in office. By 2012, the registry had opened in New Jersey. In 2016, there was only about 12,000 or so registrants, which, as compared to other states that have had these types of programs, was a very small number. And at the time, there was a lot of criticism that this law had been passed, but it really wasn't going anywhere, and the program really hadn't been developed. Next slide, please. At the time, under the medical marijuana statute, there was also litigation that happened. We often cite the classic example of forklift drivers who test positive for marijuana, and that case exactly under those circumstances happened. it went through the courts, and all of a sudden we started seeing that the law in and of itself was a little limited in what it provided, because the courts wound up finding that there wasn't really any accommodation requirement under the medical marijuana law, and that New Jersey's law against discrimination didn't really require it either. So probably, I want to say within, it felt like minutes of the New Jersey Supreme Court decision in 2019, the J. Koenig Compassionate Use Medical Cannabis Act was passed, directly responding to those to that line of cases, and explicitly providing for an accommodation requirement for employees, and really expanding the medical marijuana program. That law remains in effect today for the medical program, as it did before. Interestingly, and I'll sort of infuse this little tidbit, that was also the shift from calling it medical marijuana in New Jersey to now it's medical cannabis. There was some discussion as to marijuana, quote unquote, having discriminatory connotations that date back about 100 years. So there was a push in New Jersey, and we'll see in a few minutes in New York as well, to kind of change the nomenclature a little bit. In 2020, there was a question on the ballot during the election as far as legalization. It passed with flying colors. The New Jersey voters very strongly supported legalization of recreational cannabis. And February 22nd, 2021, big day for recreational cannabis, the CREAM Act was passed. On a side note, I'm not sure who exactly decided to name this law. It's unclear as to the connection of the CREAM Act and medical cannabis, but nonetheless, it rolls off the tongue rather easily. And that law was part of a collection of 3 laws that actually addressed creating a commission that was going to be formed, that's actually being formed right now, as far as the regulation aspects of it, the dispensaries and et cetera. There was also a law that decriminalized it, and also that clarified cannabis use and penalties for folks that were under 21. So it's actually, there was a 21 and up age limit in New Jersey, as there is with similar to alcohol. So now in that context, let's talk a little bit about what this law, the New Jersey CREAM Act, actually provides. Next slide, please. Now, for our purposes, we'll touch on medical cannabis as needed, but the real focus here is, what does the recreational law really provide? And in summary, I will say, basically, when it boils down to it, is it truly allows for recreational use of marijuana, at least in the employment context, with really no exception. And we'll talk about the tiny little sliver of an exception that exists and some thoughts that we have about its applicability. But employers, generally speaking, can prohibit cannabis use and impairment at work. The law does not provide that anybody can use marijuana or cannabis or any type of substances at work. The law does not allow anybody to go to work intoxicated. It does not have any type of requirement that an employer has to accommodate the use, possession, selling, doing anything, having it at work. That all remains intact. But where the rubber hits the road with this statute is really the employment discrimination aspect. Can you take action for off-duty use? And here, the law is very expansive. An employer cannot refuse to hire someone that tests, well, we'll actually talk about testing in a second, but anybody that uses cannabis. The only real exception under New York law is federal contractors. So if somebody has a federal contract that's implicated or federal funding that's implicated, that would be exempt under the law. But short of that, off-duty use of recreational marijuana or cannabis cannot be a basis in and of itself for any type of adverse employment action. So just to kind of summarize this slide for a second, because it's an important point, an employee is, under this law, allowed to use recreational cannabis off-duty, but there's no requirement that anybody can be intoxicated or in any way impaired at work. So that really is the distinction. Next slide, please. So we touched on testing. Let's talk about what is allowed under the law. And the law actually talks explicitly in what's permitted. Employers can test pre-employment. They can do random tests, post-accident tests. reasonable suspicion of use at work, and observable signs of intoxication. There are two components that this law contemplates as far as the test is concerned. A scientific component, so a scientifically reliable objective testing method, that would be your blood, urine, hair follicle, any of those, and a physical examination by someone that's designated as a quote-unquote wire. So let's talk about what a wire is, and this is a concept that's created under the CREAM Act, and kind of fleshed out in a little bit of detail as to what that is. A wire is basically an employee, could be a full-time or a part-time employee, who is designated as trained and certified and et cetera, as designated as the person who can perform the analysis of whether or not somebody is intoxicated at work or otherwise impaired at work. And the idea is, and this is all still developing, the idea is that once the commission is formed under the CREAM Act, they will work with the state police to design a training program for whoever's going to be designated a wire. That training program will then give the person the skills to be able to determine intoxication levels at work, impairment levels at work, and give them a rubric to work in. That person will then be involved in any type of workplace decisions as far as whether it's discipline or anything else post-accident, whether somebody was impaired at work. So the CREAM Act contemplates that once everything is developed, anytime that we're doing a test at work is going to involve a scientific method and input from the person that's designated as a wire. And then, within that context, testing will continue to be permitted. Next slide, please. But here's where drug testing is limited. The results of the test cannot in and of themselves be the basis for an adverse employment action. So what that means is that just because somebody tests positive doesn't mean they can be terminated or disciplined or otherwise have anything else happen to them. The other aspect of this is that, like I said before, the J. Koenig Compassionate Use Act is still in effect. So where there is a positive test, there's also this interplay where an employer is obligated to give notice of the failed drug test, and then the employee then gets 3 days to either provide an explanation as to why that is, or retest at their own cost if they disagree with the results. The explanation that they are supposed to provide would be to provide evidence of their legitimate medical use, proof of registration, or both under the J. Koenig Medical Use Act. So, next slide, please. What's the one thing that we didn't talk about so far? We just went through the aspects of this statute, but you haven't heard me say anything about exemptions for safety-sensitive positions. What about those forklift drivers? What about all those positions where safety is a factor? No exemption under this law. So that effectively means if someone is, like I said, the quintessential forklift driver, and they're engaged in off-duty use of cannabis, recreational cannabis, there would be no basis to either deny them the job for a failed drug test or to discipline them for off-duty use. On-duty use still can be the basis for discipline or anything like that. Now, the CREAM Act doesn't have a safety-sensitive exemption per se, but there are obviously workplace safety rules. OSHA still applies. There's still a lot of safety rules, and Adam will touch upon that a little bit because it does require getting into detail a little bit. So I'll let Adam talk about that in a little bit more detail, but I did want to flag that because the CREAM Act itself doesn't have a safety-sensitive exemption, but there are other laws at play that may be triggered, and there will be some interplay between them. One thing that's important to note about the New Jersey statute also is that the effective date is not actually clear yet. So, you've heard me mention the commission and the fact that they're developing rules and regulations, and the fact that they're creating this wire program. All this is on hold basically until all that is finalized. So the commission, the last I had heard, Governor Murphy was appointing the commissioners. One of the organizations sued because they didn't get a seat on the commission, so they sued and said that they have to, and they're making him put somebody on the commission. So we'll see where that goes. But once the regulations and once all that is set, then the law is supposed to go into effect either 6 months after the passing of the law, or 45 days after the appointment of the commissioners and what they're doing. So I want to say the conservative estimate is that neither of these things can happen and trigger the effective date prior to August 23rd, which is the 6-month mark. So we'll see a lot of developments between now and then. One other thing to note is that there is no express right of action, private right of action for employees, which means employees will not be able to sue under the CREAM Act. Now, broadly speaking, in New Jersey, for example, there is the New Jersey law against discrimination. So if there's a medical component of any kind, theoretically, at least, there could be some sort of tie-in to disability discrimination. Another aspect of this is the New Jersey Conscientious Employee Protection Act. Theoretically speaking, there could be some interplay in capturing the private right of action under SEPA to file a claim for recreational marijuana use. And in New Jersey, you always have the Pierce versus Ortho ability to sue for wrongful termination as against public policy. And the New Jersey CREAM Act would qualify as an expression of public policy that could hypothetically trigger a cause of action under New Jersey common law. Next slide, please. So let's talk a little bit about pre-employment inquiries regarding criminal history. One of those other laws that were passed in addition to the CREAM Act effectively provided that there can be no inquiry regarding arrests or charges or convictions involving marijuana or hashish. So an employer would not be able to disqualify an applicant on the basis of a prior criminal history that relates to this cannabis subject matter. Again, no private right of action here, but this in the administrative scheme, there are some administrative penalties if that were to occur. Next slide, please. So let's talk a little bit about, it's been what, 6 weeks now that this law has passed. Let's talk a little bit about what's happened since then. We checked yesterday. There is a cleanup bill that's been proposed by Senator Paul Sarlo out of Passaic County, which would basically make the use of a wire, the person that's been trained to assess intoxication levels, would make the use of that type of person optional. And it would also create some safety sensitive exceptions based on industry, such as critical infrastructure facilities, construction sites, transportation jobs, law enforcement, and folks that work subject to the Railway Labor Act. As of yesterday, it's been proposed. It has had no movement. It's a little early to tell us where this will go, whether other laws will also be proposed to clean up some of the CREAM Act verbiage. We will continue to keep our eyes, on these developments, and we'll probably have legal updates on those as they happen, but so far, not a lot yet. Now, what's interesting too is that just about every day on local news, we hear about the marijuana segment, where they talk about what's been going on there. And we've seen a lot of communities that are taking very divergent views. There are communities that are embracing cannabis and the new industry, and there are some that are already rejecting the dispensary business. For example, two easy examples that are really neighbors. Paterson, New Jersey is embracing the dispensary business. Wayne, New Jersey is. They had a town hall meeting last night, as a matter of fact, to talk about the fact that they do not want this type of industry in their community. So to kind of capture New Jersey, recreational marijuana is in play. Within probably 6 months to 9 months or so, we'll have more developments as to the employment implications, the wire designations and the trainings, and we'll see the developments here, as they come. Let's talk about New York for a second, because New York is literally just a few days old. New York has a similar history to New Jersey with, prior to 2015, New York City was really on the forefront. The mayors, Giuliani and de Blasio, really taking a different angle of trying to regulate police activity and folks that were getting arrested for marijuana. In 2015, Governor Cuomo passed the medical marijuana law, but it was very limited at the time. There was only a few licenses that were granted. But as 2020 kicked in, and there was a lot of activity across the river in New Jersey, there was a lot of pressure to do something similar in New York. And on March 30th, literally, a little over a week ago, Governor Cuomo signed the Marijuana Regulation and Taxation Act, legalizing the sale and use of cannabis for adults over 21 years old, and also amending the employment laws. So similar to New Jersey, employers can still prohibit impairment at work and use at work. Employers can still have a drug and alcohol-free workplace, and there's no requirement to accommodate any type of use or possession or anything like that at work. However, the way that New York structured its employment aspect of this law, New York has an off-duty conduct statute that basically allows employees to engage in off-duty lawful conduct without consequence at work. In other words, employees are prohibited from taking adverse employment action based on lawful off-duty conduct. That law was amended to also reference the use of cannabis. Now that cannabis is lawful, it would qualify as off-duty lawful activity. So an employer cannot refuse to hire or terminate or otherwise take any adverse employment action based on off-duty legal use of cannabis. Next slide, please. Now, unlike New Jersey, New York had a little bit broader of an exception. It also limited that off-duty conduct statute to exempt activity if it implicates federal or state law. So, for example, an employer can take an adverse employment action if federal or state law would otherwise require them to. An easy example of that would be DOT. DOT has a lot of regulations that might be triggered here. That an employer would otherwise be in violation of a federal contract, federal law, or be subject to losing federal funding. So that would be another basis where an employer could take adverse employment action for lawful use of cannabis. And last, and kind of the middle bullet there, if an employee is impaired, manifests specific articulable symptoms while working that increase the employee's performance, or if it interferes with the employer's obligation to provide a safe and healthy workplace. So there is a little bit of language baked into this act that implicates the safety-sensitive exemption in and of itself. It's not developed, will probably be the subject of litigation to really figure out what it means, but it does really open the door for employers to be able to cite to some provision to say that there is some safety concern or safety implication, unlike the New Jersey law. Next slide, please. It's important to note with drug testing that New York doesn't really regulate drug testing, so there's no real restriction on pre-employment, random, post-accident, reasonable suspicion. These tests could implicate anti-discrimination laws at times, so that is something to be sensitive to, but there's no law directly regulating an employer's ability and when they can drug test. But in New York City, as of mid-year 2020, pre-employment drug testing specifically for marijuana is prohibited. There are exceptions, so if you're operating under DOT regulations, federal contracts, et cetera, there are a limited number of exemptions where pre-employment testing would be permitted in New York City, and testing of current employees would still be permitted in New York City. But pre-employment drug testing in New York City is prohibited as to marijuana as of last year. Next slide, please. Here, I'll let Adam talk about the workplace safety rules as well. The effective date of this law, it's not really addressed in the law. The law was passed effective immediately, and there was a lot of carve-outs as to which aspects of the law are deferred or triggered by some other activity. In and of itself, right now, the most conservative interpretation would be for the law to apply now, to adhere to the New York cannabis law as of now, as if it's in full effect. But like I said, it is a tangle of dates that the law provides. And this law, just like New Jersey, does not provide a private right of action. Next slide, please. Similar to New Jersey, and this has only been a week, so we don't really have as much activity post, but the one thing I did find a little bit ironic or funny, if you will, similarly, certain communities are coming out strongly in favor or strongly opposed. The town of Amsterdam, I thought was kind of funny that they've come out strongly opposed to the business, and I only found that funny because of the real Amsterdam in Europe and how they've differed in their opinion. But that provides a summary of the recent legislation in New York and New Jersey. Recreational cannabis in both states allowed as of within the last couple of weeks, basically, and we're going to be seeing a lot of developments in both states, largely because of the broad phrasing of these provisions and how they impact employers. So with that, and without further ado, I know I promised some discussion on workplace safety rules, and Adam, hit it out of the park. Go ahead, Adam.
Right. Well, thank you very much, Robert. Hi, everyone. My name is Adam Young, and I'm a partner with our workplace safety and employment groups. I'm going to go on to the next slide. I'd like to talk a little bit about, understanding drug testing, and we'll back things up a little bit on marijuana and understanding what's going on here. The psychoactive chemical within marijuana is called THC, or tetrahydrocannabinol. I mean, those are metabolites in the bloodstream or in urine that can be tested for. And we get a lot of questions about drug testing and what it means, and I do a lot of policy work for drug testing and how to use drug tests once we get those results back. So I would like to provide a little explanation on that. The drug test for marijuana is actually two drug tests, right? It's an initial test and then a confirmation cutoff. The initial test to fail, you're failing at 15 nanogram over milliliter, 1.5. And typically with the confirmation cutoff, it's at 50 nanograms over milliliter. There's also a medical review officer that's listed there. So if someone has some sort of medical explanation, they can communicate directly with that person and not you about that. Can a drug test prove impairment? And the answer is generally no. It's correlated with impairment, right? We have all these regulatory structures that are set up where impairment is presumed if you fail a drug test for the Department of Transportation agencies or for other organizations like that. But it doesn't necessarily prove that you were specifically impaired when you gave that sample, but it is correlated with impairment. A lot of questions I get is, well, this employee came to me and he told me he was at a concert last Friday and he was only smoking cigarettes, but there was a contact high because marijuana was blowing around him, and that's why he failed the drug test 4 days later on Tuesday. And that is generally not an accurate description of drug testing or the results. They've done tests in Canada where they blow marijuana smoke into rooms full of people. None of those people actually smoked marijuana themselves. It's just blowing in the air, and none of those people fail the drug test. The 50 nanogram over milliliter, none of them reached that because typically the story is false, right? They actually are using that drug. It's not, I'm sorry to say, but the friend that was at the concert and thought he was smoking clove cigarettes, probably not a realistic explanation of drug testing. I'd like to give everyone the CLE code. I'm getting an email about that. It's SS9446, SS9446. I repeated it twice. So that's the code if y'all want to get CLE credit. So that's kind of a general explanation of what marijuana testing is. We track the data from Quest Diagnostics on positivity rates for marijuana testing. The number one driver of increased positivity anywhere in the United States is after that state legalizes recreational marijuana. So from our experience in California, Illinois, all the different states in the United States where companies have dealt with employees and those states have legalized recreational marijuana, we're seeing more positivity. So more people are failing drug tests, more people are likely impaired at work. So, that's one of the reasons why these New Jersey and New York laws matter the most. Understanding drug testing a little bit here. After an individual smokes marijuana, the THC spikes in their blood and then slowly tapers off over time. As I said, it's not directly correlated with, it's not directly, there's no direct causation we can show with impairment, but in terms of subjective impairment, it seems to last at least 2 hours. The THC concentration is only over 50 nanograms over milliliters for a pretty limited time, at least in this NHTSA study. It may be longer, if you look at other data, but typically it shows within 2 hours that person is impaired and that person is going to fail a drug test. The question, does it linger in your system? That's the other question we get a lot. Well, someone is just going to use it recreationally on Friday nights. Are they going to be impaired at work and fail a drug test? So maybe they're not going to be impaired at work if they took it on Friday night, but if they are failing a drug test on Monday, it's typically not because they used it on Friday night. It's because they are impaired, because they are able to fail both of those drug tests. If we go on to the next slide, problems caused in the workplace. So I do OSHA law and workplace safety law. I deal with workplace fatalities. I'd estimate 30 to 40% of all the fatalities we see, the coroner's report, so the test on that person's dead body, shows positivity for drugs or alcohol or both. Recently, I had a case, an employee was working on a tower, a communications tower. He disconnected himself 250 feet above the ground, and he fell 250 feet to his death. And when the coroner examined his body, he found positivity for drugs. I have another case a couple years ago where a man stepped in front of a moving 40-ton piece of equipment and was crushed to death, and he was in cardiac arrest within an hour of that. And the EMT who performed cardiac arrest on this individual felt the guy's ankle, and on his ankle was a canteen, and in that canteen was urine. The employee was a frequent user of marijuana, and he carried urine with him every day to work so that he would have clean urine in case a drug test took place. We don't know why he stepped in front of that piece of equipment, but it may have been that his impairment by marijuana caused that incident. So that's the tip of the iceberg there. It can result in safety incidents, specifically serious injuries or death. And those are accidents not just to individuals at the work site. If you're a company that operates cranes, if your crane operator is under the influence of drugs or alcohol, or specifically marijuana, maybe they drop a piece of material on members of the public or visitors or other third parties at the work site. So safety incidents, fatalities, tip of the iceberg. Safety incidents are broader, but there's also associations between marijuana and lack of performance. So absenteeism is associated with marijuana, poor output. Somebody types something in wrong, data entry is wrong, maybe you lose a lot of money because of that. There's other reasons you might be concerned. Theft, it says increased liability to the company. I can tell you, at least anecdotally, a lot of sexual harassment incidents when people were still in the office were associated with drugs and specifically alcohol. So marijuana heavily associated with other types of liabilities. Workplace violence is a huge concern when it relates to marijuana. We have had cases not just where people who are impaired by marijuana have workplace violence outcomes, but by people who are dealing marijuana at the workplace. So marijuana sales were associated with both a drug and prostitution ring at one of our clients. It's a very concerning issue for those reasons. If we want to go on to the next slide, what are some of the reasons you might want to test employees for marijuana? One is Department of Transportation. A lot of the DOT agencies require a testing regime for commercial drivers or drivers of commercial vehicles. OSHA requires a workplace that's free from any recognized hazards at the workplace. They don't have specific regulations requiring drug testing, but there have been citations issued where people knowingly are permitting individuals who are violent or knowingly permitting individuals who are users of drugs and alcohol in the workplace who cause workplace violence. So there's that end to it. Some states have workers' comp premiums based on having certain drug and alcohol policies, so that's another reason why you might want to have that. If you want to go to the next slide. Generally, companies want to do drug and alcohol testing because they want to have a safety culture. If you have drug and alcohol testing, you're often, or drug testing, you're often so screening out people who don't want to be drug tested. So you have a safety culture, you have a drug-free culture. You may also have contractual obligations that require drug testing, and that's typically through a collective bargaining agreement, which will outline what types of testing are permissible. Now, going on to the next slide. So how are employers dealing with this issue? You know, I'll talk in more detail, but many are limiting drug testing for marijuana to certain safety-sensitive positions. How do you define safety-sensitive? Typically, if you're impaired by drugs or alcohol, that will make a material difference in terms of your safety or the safety of others at the work site. It's one of those things like you know it when you see it. If someone's operating a forklift, which is the example that Rob gave, working around conveyors, operating any type of heavy industrial equipment, saws, energized equipment, using hazardous chemicals, those are all things that are associated with safety-sensitive positions. Obviously, anyone who shows up to a work site impaired is more likely to get into an incident, and that could be slipping and falling in your parking lot. That could be walking in front of a car in the parking lot and getting hit by a car, and those are things we've had happen to clients before. So anyone is going to have some increased risk of an incident if they're impaired. The more material risk we see from the type of hazardous equipment. The National Safety Council, which is the largest association of safety professionals in the United States, they recommend a zero-tolerance policy for marijuana for employees in safety-sensitive positions. And that means you should not tolerate marijuana at any level in those employees, according to the National Safety Council. And the reason why is they give all these increased statistics, right? So you're 85% more likely to get into a car accident. You're 64.5% more likely to have an OSHA recordable injury. You're 58% more likely to have a near miss at the work site. So they give all these different statistics in their white paper that explains why they recommend zero tolerance. If we want to go on to the next slide. Now, so do these New York and New Jersey laws suggest that they will have an adverse effect on employee safety? I think the answer, at least from what we understand so far and how they look like they're going to be implemented, the answer is probably yes, right? If a medical marijuana card is a defense to a positive drug test, as it appears to be under New Jersey, well, I have this medical marijuana card, so that's why I have this positive drug test, that could allow someone to not face an adverse employment action who is impaired at work in a safety-sensitive position, right? If you can't take an action solely based on a positive drug test, then that may be a person who is impaired and you don't have some sort of articulable basis for that impairment that you can't take actions against. New York, I was most shocked when I saw New York's prohibition on taking adverse action based on legal use before a job shift. So if your crane operator told you, look, I just smoked marijuana at 8:55 and now I'm running this crane at 9:04, you couldn't tell them, hey, you're fired, hey, get out of there. It's unclear, you know, what your permissible options are in that type of scenario. But we'd be very concerned from a safety perspective with somebody impaired by marijuana, and pre-shift use of marijuana is going to be highly correlated with impairment. And I don't think there's any ifs, ands, or buts about that. If we want to go on to the next slide, these slides, you guys are going to have these presentations, but they talk about the different types of drug testing and how these laws may affect those types of drug testing. And you may want to be reevaluating your program. In a lot of states where recreational marijuana was legalized, clients have reevaluated post-offer pre-employment testing. Some clients are taking it off the panel. Others are still doing the post-offer pre-employment testing. And if an employee tests positive or an applicant tests positive, they have a conversation with them. Look, you know, you failed the drug test. We don't tolerate impairment. This is correlated with impairment at the time of the drug test that you gave. Are you going to be using marijuana going forward? Are you going to be impaired at work? Having that type of conversation with them. And some of our clients in the healthcare field have used that and found it to be successful, and having that frank conversation they find to be effective. If we want to go on to the next slide, reasonable cause testing. This is the, you know, reasonable suspicion type testing based on speech, behavior. What's difficult about marijuana is there's not a lot of articulable facts associated with marijuana use along the lines of alcohol, for instance. People aren't staggering. It's not clear that they're going to have motor skills impacted. There may not be any reason that you would know that they're high under the influence of marijuana. But if we go on to the next slide, there's procedures that we recommend for doing that. If they have training, we have training materials we can provide, training your managers on how to recognize reasonable suspicion for drug testing. The key thing there is documenting anything you say. Have a credible source, of a manager who can record that, and then doing the testing promptly. If we go to the next slide, this provides some of the signs and symptoms, and I'm not going to read them to you, but these are things that are associated with drug and alcohol use more broadly. Unfortunately, with marijuana, there are many other drugs like methamphetamine. It's difficult to tell if the person is on. But repeated absenteeism, missed performance indicators can also be things that you could associate with reasonable suspicion. And because the wire or the reasonable suspicion identifier under the New Jersey law is going to require this type of documentation, you may want to consider not just documenting those physical characteristics, but also behavioral characteristics and work performance that might be associated with reasonable suspicion of drugs and alcohol use. If we want to go on to the next slide, there's a lot of traps when it comes to reasonable suspicion where people get cozy with their employees. They don't feel like they have the confidence. In my experience, just training supervisors on reasonable suspicion and identifying reasonable suspicion will greatly increase the number of reports you get because they'll have more confidence, they'll be more comfortable addressing the issue. If we want to go on to the next slide, this discusses random testing and opportunities for doing random testing in the work site. New Jersey's law says, a drug test can't be the sole basis for the adverse employment action. If you do random testing and someone fails it, I'm not sure what your other basis is going to be for that adverse employment action. So there may be a reason you'd want to reconsider random testing, and we'd be happy to dig into that with you on the New Jersey law. We're going to go to the next slide. This addresses return to duty testing, which is very commonly done, often with like an employee assistance program. If someone is offered, not terminated based on drug or alcohol use, leaves the work site, returns to duty, there's often testing requirements that are built into that, and that's pretty common. It will be difficult to understand how those need to be updated. If those New Jersey law does require that, you can't revoke an offer based on that, or otherwise have an adverse employment action on that employee. If we want to go on to the next slide, this discusses post-accident drug testing. If you have a post-injury drug testing policy now, that's per se unlawful. So you shouldn't be having a policy that just tests anyone who gets injured. That's probably workers' comp retaliation in New Jersey and New York. I haven't read that case law, but it's something you should be reevaluating. In terms of post-accident testing, it likely would be permissible in both these states, because the failed test wouldn't be the sole basis for taking that adverse employment action. There also may be a safety rule violation involved. In terms of OSHA's clarification, they said, well, you can't just test the person that gets injured. You also have to test anyone whose impairment could have caused the incident. So there's some guidance there that it may be considered retaliation under OSHA if you don't test everyone who was potentially impaired. If we want to go on to the next slide, let's discuss how are employers addressing this issue. I would say the most common thing we're seeing is still prohibiting that on-site use, prohibiting possession at work, prohibiting impairment. The employer doesn't have to tolerate use, even if you have to tolerate the use at home in New York of recreational marijuana. You don't have to tolerate it at work. So those are typical things that are policies. One issue that employers run into is that they'll just have illegal drugs as the thing written in there, and maybe that becomes ambiguous, right? Recreational marijuana is legal now in New Jersey and New York. How are you defining a legal drug? We have a model policy. We'd be happy to send you on that definition, and that defines things as cannabinoids and cannabis, marijuana, derivatives, and things of that nature. So you could define the terms in a way that is inclusive of all the marijuana products out there. If we go to the next slide, This talks more generally about how employers may be addressing the issue. Some people are saying, let's just get over marijuana. Let's take it off our panels. Let's not have policies about marijuana at this point. Many are still doing post-accident testing. I did get interviewed by a newspaper about a company in this country that's creating a cannabis bar at the workplace, so people can do cannabis at work and micro-dose and become much more creative. I would say that is more an exception than the rule. That it's more common that employers are taking that middle approach where they're still testing and they're still prohibiting use and possession and impairment at work, and for the safety reasons we talked about, but also for productivity and ensuring that employees are doing a good job. So that's the safety side of things. And again, we're happy to answer any questions you may have. I'll turn things back over to Jen.
Thanks, Adam and Rob. That was great. So I'm just going to kind of wrap it up with some general considerations that we deal with. We have a pretty strong drug testing practice and marijuana use practice. We get a lot of questions all over the place about the issue, and so we want to kind of just touch on some additional issues beyond New Jersey and New York. Adam and Rob both talked about DOT exceptions in the laws. DOT has taken a very, very strong position. If you are subject to Department of Transportation Part 40 drug testing, you cannot ignore a positive test result, even for medical use. In 2009, so it's been 12 years now, DOT actually put out a bulletin regarding their position on the issue. And so the issue to be clear about, however, is that DOT does not say that you have to terminate that person. It does not dictate a course of action, except that you can no longer allow them to perform DOT-regulated safety-sensitive duties until they go through this substance abuse professional counseling type process, and then they're allowed to come back to work. And so then in that situation, you are going to be having to look at state law then, right? So you take them out of the DOT-regulated job. Well, are there other jobs for you to give them, especially if you're in an employee-friendly state like New Jersey or New York? So that's something to think about. Be very careful about relying on the Drug-Free Workplace Act. Early on, we started to see some litigation where courts said that employers that are subject to the Drug-Free Workplace Act can go ahead and ignore these laws. We're seeing now cases going to the opposite. The Drug-Free Workplace Act simply says that government contractors have to have a drug-free workplace, and they have to roll out a policy saying that. It says zero about drug testing. It also says zero about the ability of somebody to use off-duty. So be very careful about that. While a lot of these laws have exceptions for regulated employers, I think that it's going to be difficult to rely on the Drug-Free Workplace Act in some of these jurisdictions because you can comply with state and federal law on this issue. We're getting a ton of questions about CBD. Adam talked about the guy who went to the party and claimed that he got high because he just happened to be around it. What we're seeing a lot right now is that employees and applicants are using CBD that's touted as being THC or pure CBD. If you guys don't know, or you all don't know, the FDA is trying to get up to speed right now. CBD is not a regulated product, but what we're seeing is that there are a lot of CBD products that, even though they say they're THC-free or pure CBD, they actually have enough THC in them to result in a positive THC marijuana test result. So what ends up happening as an employer is you'll test a job applicant, they'll test positive for THC, and their excuse is, well, I took THC-free CBD, this can't be possible. Well, how do you know as an employer whether or not they're being truthful, right? Because maybe they'll even show you the product and it says THC-free. We put out a blog about 1.5 years ago, and we talked about the science behind CBD, and we found that there have been some studies that have actually tested CBD products that say THC and pure CBD on them, and they in fact are spiked with THC. We do know of one case where an applicant for a driving position, I think it's a Philadelphia case, sued a CBD manufacturer for false advertising because he was rejected for a job, and according to him, he never smoked marijuana, he never used anything like that. It was just this CBD product. DOT recently put out a bulletin that essentially said that, look, if somebody tests positive for THC, we don't care if they say it's because of CBD. The problem is that they were clearly taking a product that has enough THC in it to result in that test. And when that's the case, the product then becomes illegal under federal law. So there's a lot of this tension going on. CBD is going to be a $20 billion a year industry in the next couple of years. So Virginia just passed its first, it's the first state in the nation to provide employment protections to CBD users. It's very similar to the laws that we're seeing in other jurisdictions. You know, you don't have to tolerate it if you're a federal contractor. And the Virginia law does say that if somebody tests positive and the THC level is a certain level, again, that's going to suggest that it's not pure CBD. So that's something to kind of watch, and we'll start seeing more laws being enacted that way. Rob and Adam already talked about New York City and Nevada. I will add, Nevada says you can't rely on a positive cannabis test result pre-employment. There are some exceptions for safety-sensitive jobs. Keep in mind that drug testing statutes are separate and apart from medical marijuana laws. So a lot of what we're talking about is coming from a marijuana statute, but a lot of states and case law talks about what your policy has to say, or even talks about what you can and can't do as it relates to drug and alcohol testing. So some jurisdictions are very, very regulated, Iowa and Minnesota. In Maine, you cannot do drug testing at all of your employees until you get your policy approved by the state. And some of these restrictions are based on what we're learning from cases. So take a look at your drug testing policy. As Adam said, make sure that you're being very clear in your policy. I like to think of a drug and alcohol testing policy as you know, these are your rights and these are the expectations, you know, making sure that there's kind of a measure of due process. Do employees know that your policy prohibits marijuana? Do your employees know that your policy prohibits CBD that might result in a THC test? Be very, very clear about that so people aren't bringing claims over the vagueness. Duty to accommodate, you know, we're running out of time, so I just want to get through this. You know, there's no duty to accommodate marijuana use under the Americans with Disabilities Act. We did just, if you want to check out the blunt truth, we just put out a blog on a decision about that. The states, however, and some courts are going to the opposite direction. We've got a couple of cases up on the slide that have specifically said employers have to at least consider off-duty use. What does that look like? Again, what the employer or the applicant might ask is that, particularly in the medical context, that the reasonable accommodation be that you bend your drug and alcohol testing policy to allow them to use their marijuana off-duty. But at the end of the day, the employers that are getting sued over this, what they're not doing is they're not at least engaging in an interactive process, particularly in those states that I identified early on that are pro-applicant and employee as it relates to medical use. So, you know, I'm just going to close out real quick because it leads into what I want to point out, which is that before you do anything in any jurisdiction, you really need to know what the law says in your state, because that will then drive what are you doing with your policy, what are you doing with drug testing, what are you doing when a positive test comes back, and what are you doing if somebody says that they're a medical marijuana user. Engage in an interactive dialogue. All it is a conversation. It doesn't necessarily mean you have to give them the accommodation that they seek. Make sure you're always considering your culture and your goals. You know, you might find that you're having a hard time finding people to hire because, you know, you happen to have an industry where there's a lot of pot smoking people out there, and you might decide, well, we're going to be okay with it. And again, review your drug testing policies and make sure that, you know, employees understand what's expected of them and what you plan to do if there is an issue. We have a minute. Rob or Adam, did you guys see any questions that you quickly wanted to just chime in on before I hand it off?
Sure, Jen. There was a question. Yeah, there was a question about impairment levels defined under New Jersey and federal and different laws at play. I'll say that the commission that's being formed in New Jersey is probably going to address that in terms of their training for the WIRE program, because they're supposed to be the ones that are assessing intoxication levels. I'm not sure that New York has any guidance on what the level of intoxication is. Adam touched on some of the statistics, and Adam, you can chime in as to what the standard would be for to be considered a level of intoxication as a guidepost. What do you think about that?
Yeah, sure. 50 nanogram over milliliter is typically the standard that's provided for a failed drug test. In terms of other questions that we received, one was, can you take action against an employee who tests positive for cannabis if the employee is a safety-sensitive role that requires DOT random drug testing? And the answer is absolutely, you have to. The DOT agency requires that you remove that person from driving if they fail a drug test. So the answer to that question is yes. I don't know if you guys want to address the other ones.
I think we might be running out of time, so we will, I will say thank you on behalf of Rob and Adam. If you have questions, definitely reach out to us. We're always happy to help. We really appreciate that you joined us today and hope you have a fabulous afternoon.
Thank you.
Thanks, everyone.